Ladies and gentlemen, please join us in welcoming to the stage the Honorable Ketanji Brown Jackson, Dean Alan Morrison, and U.S. Supreme Court Justice Stephen Breyer.
Good afternoon. Ooh, it's a little loud. My name is Ketanji Brown Jackson, and I am a district judge on the United States District Court for the District of Columbia. Now, I am here to give an introduction, but first, can I just acknowledge how much this feels like my fantasy of being a speaker in one of those televised award shows? I mean, the way we just entered, it almost makes me want to begin by saying, first, I would like to thank the Academy. But I won't. Instead, I will start by thanking ACS for making my dreams come true and for the incredible work that you do every day to advance the cause of justice, to promote the rule of law, and to champion our constitutional norms. These are values that should never be taken lightly, and ACS does the heavy lifting of building networks and fostering national conversations about important issues. And for that, we should all be very grateful. Now, one person who certainly appreciates the work and the mission of ACS is Alan Morrison, who is here today and is the Lerner Family Associate Dean for Public Interest and Public Service at the George Washington University Law School. Dean Morrison currently teaches civil procedure and constitutional law and serves as GW's ACS faculty advisor. But for most of his career, Dean Morrison worked at the Public Citizen Litigation Group, an organization that he co-founded with Ralph Nader and directed for over 25 years. Among other things, Public Citizen focuses on such issues as improving access to justice. And in addition to devoting himself to this important work, Dean Morrison has also served as an assistant United States attorney and a commissioned officer of the U.S. Navy. A graduate of Yale College and Harvard Law School, Dean Morrison is a member and past president of the American Academy of Appellate Lawyers, and also has the rare distinction of having argued 20 cases in the Supreme Court. So I am sure that we're in for a treat as Dean Morrison brings his knowledge of the court to bear for this afternoon's discussion with his friend and our other distinguished guest, Justice Stephen G. Breyer. Now, Justice Breyer is so well known after nearly 2.5 decades as an associate justice that he almost needs no introduction, but here goes. Justice Breyer was appointed to the Supreme Court by President Bill Clinton in 1994, and prior to this appointment, he had a long and distinguished legal career, the professional highlights of which include a post-law school clerkship for Supreme Court Justice Arthur Goldberg, service as an assistant special prosecutor on the Watergate Special Prosecution Task Force, service as chief counsel to the U.S. Senate Judiciary Committee, and an appointment to the United States Court of Appeals for the First Circuit, on which he served for 4 years on that court as the chief judge. Now, for many people, it is understandably difficult to devote yourself to more than one occupation at a time, but not so for Justice Breyer. At the same time that he was serving in those various high-level professional positions, he also undertook to create and establish the federal sentencing guidelines as one of the first appointed commissioners of the United States Sentencing Commission, and he taught scores of graduate students as a full professor at Harvard Law School and Harvard's Kennedy School, where he developed an expertise in administrative law and wrote extensively on a wide variety of subjects. And amazingly, Justice Breyer juggled all of these professional responsibilities while also fulfilling what I'm sure he would say is his most important duty, being a husband and a devoted father to his 3 children. Now, at this point, I'm sure you've discerned that Justice Breyer has a ceaseless ability to multitask. And you should know that this talent for doing many different things at once has not diminished at all since his appointment to the Supreme Court. For example, he continues to be a prolific writer, even today, and he has authored 3 books, each of which has received critical acclaim. Hello? Neil? Yes, I realize I'm supposed to turn off my phone during public appearances. Yes, this is embarrassing, but it happens to the best of us, and I know the justice will understand. Okay, talk to you later. Sorry. Where was I? Justice Breyer, yes, is a prolific writer, and thanks to ACS, you have an opportunity to purchase a pre-signed copy of his most recent book, The Court and the World, out in the lobby here today. So how do I know so much about Justice Breyer? Well, in 1999, Justice Breyer plucked me from obscurity and gave me the opportunity of a lifetime, which was the chance to work for him as a law clerk, and thereby bear witness to the workings of his brilliant legal mind. It was an incredible experience just to be in the room while the justice grappled with some of the most difficult and consequential legal issues of the day. But one of the things that I remember most vividly from my clerkship has nothing to do with the law. It was Justice Breyer's passion for cycling. Almost every day in the fall and the spring, the justice would show up in the morning in chambers wearing full bicycle regalia. The jersey, the bicycle pants, the cleats, the whole 9 yards. And he regularly commuted to work on his bicycle, weaving his way through rush hour traffic. And I can tell you the marshals were not very happy about that. But in his incredibly modest and unassuming way, Justice Breyer didn't want any special treatment. He was just an ordinary guy getting his morning workout en route to one of the most significant jobs in the world. Now, as strange as that seemed at the time, upon reflection, it is clear to me that Justice Breyer's chosen mode of transportation made total sense because cycling is the perfect metaphor for the Breyer clerkship experience. You can ask any of his law clerks. When it comes to the law, the justice's mind moves so fast and so effortlessly that his ideas often present themselves to you like a blur. And just when you think you might be able to track one of his thought processes, it whizzes by at warp speed. It really was not unusual for the justice to be so far ahead of everyone else in his mind regarding some complicated legal issue that he would enter the discussion mid-thought, and sometimes even mid-sentence, and he rarely slowed down for anyone else to catch up. So, as a clerk, you quickly learned that the first goal, when the justice started to speak, was to figure out which case he was talking about. We'd have those funny moments where the clerks would be glancing at each other. Is that yours? No, it's mine. It's mine. That's my case. And then once you had that figured out, the best you could do was try to understand where he was in that moment so you could engage with him, which was very much like having to mount the back of a back half of a speeding racing bike for two. Imagine Justice Breyer in his bicycling shorts at the helm, pedaling furiously, and the assigned clerk has to figure out who's up, sprint to catch up with the moving vehicle, hop on, analyze the existing pedal rotation, click in, and try to match his speed and tempo, and ultimately hold on for dear life. It was a bit of a challenge, but it was also an incredible thrill, and I am not alone in saying that, without a doubt, being a law clerk for Justice Breyer was one of the most rewarding professional experiences of my life. Therefore, it is with enormous pride and great devotion that I eagerly await the journey that Dean Morrison will take us on today as he converses with the justice. Let's all buckle our seatbelts, and without further ado, I give you Dean Morrison and Justice Stephen Breyer.
That's really nice.
My first and most important question today is, how are you feeling? How's your health?
Well,
If your mother were around, she would ask you, are you eating your vegetables?
Yeah, but sometimes people do ask me that. Usually the worst one was a woman came up and said, ever since the election, I've been hoping you wouldn't die. And I said, well, actually, I was hoping that even before the election. You turn this off. That was a very nice introduction, Ketanji. She is a little biased. She was my law clerk. She was a great law clerk. Despite all those difficulties, she's gone on to great success being a judge. It's great. And Alan is a very, very old friend. My goodness. Shakespeare had that on here, Henry IV, Part 2. And the old judge is there with his old pal from law school. And you know what he says? He says, those were the days. Yeah, but they still are.
Yes.
And when I heard Ketanji, I thought, because I see Jimmy Fluke here, we both worked for Senator Kennedy. And the first rule of working for Senator Kennedy, which I've engraved, 7 rules I learned to put up my law, I give them to my law clerks. The first one was for the people on the staff. What did he say? Wasn't it? It was. But I'm fine.
And you're bicycling? You're not bicycling?
Well, I had a few problems with my bike. It wasn't
Yeah.
exactly a problem with my bicycle. It was a problem with my putting out my arm like that at the wrong time. That was a possible error. So actually, the doctor said I could bicycle. He said, but if you fall off again, you're going to feel like such a moron that it's better use a stationary bike. So there we are.
So we don't need to go through your ancient history, but I'd like to start talking to you about your clerkship with Justice Goldberg and what it was like, obviously being in a quite different position from the one you're in now. And also, can we talk a little bit about how the court was back then as compared to what it is now? And I'm going to ask you some more specific questions in a minute.
I mean, those were good days. First, they only had 2 clerks then. Now we have 4. Steve Goldstein and me.
And you had many more cases, right?
Yeah, it doesn't seem like that. I mean, interestingly enough, it may be most of the overachievers who were there tend to have the work expand to fit the time regardless. And that does tend to happen, in law schools and with lawyers and other places. So the cases didn't seem significantly different. The cert system was a little bit different. But what was nice for the clerks was that Peter, I think, yes, you're here too. Good. We have several. and Peter Edelman's here too. And which is nice. We got to know Justice Goldberg pretty well. And Peter and I worked on all his losing campaigns. We did. He was fun. He was really fun. It was, we'd go to lunch with him, and it was interesting, and it was a very, very good year. The court, I think, looking back from now, was different. But it was different because, if I had to characterize it, I think at that time, 64, 65, and you were 62, 63, it was a court with a mission. They had decided Brown in 54, and not all that much had been happening. I mean, some things had, of course, but the legal apparatus that sustained segregation in the South and sometimes elsewhere was very complex, and it had lots of different parts. And Congress had not dived in to help the court. And so the question continuously coming up was, we don't want to have written an opinion that then never was put into effect, really. And at least we want to be sure that that legal apparatus is gone. And I would say that was the overarching mission of the court. And nobody disagreed with that, really.
Well, how about the criminal law aspects? I mean, there
Well,
was
then
a
things
huge
I
amount
think,
going on there at the time.
Correct. There were, of course, the selective incorporation. There were lots of other things happening. But this is just my own view of it, that I think that a lot of the things grew out of that basic idea that the Constitution in the 14th Amendment says equal protection of the law. When I grew up, you'd have to have been a blind idiot not to see that vast numbers of people were not getting that protection. And so they took what the Constitution said, and they said, we're going to try to make it, at least as far as the law is concerned, a reality. Now, you look at other parts of the Constitution, and from what I read and believe, certainly at the time, Earl Warren knew he had been a district attorney in Oakland. And he wanted Miranda because he thought that's the way to bring this under control. But you see, that's part of the effort to make the Fifth Amendment real. and dismantle that legal apparatus that is getting in the way. And the same is true with a lot of the amendments that went through the 14th to the states. After all, in the 1870s and late 1860s, senators and the northern victors, and probably a lot of others too, wanted to make that Constitution, which had been aimed at the federal government, valid as well against the states. And for a long time, not much happened. So I tie these different things together, whether it's the First Amendment through the 14th, or whether it's Miranda, or whether it's lots of other things. I see them as part of an effort to make the constitutional protections real in the law, and beginning with that Brown versus Board.
At that time you were clerking at the court, there were many fewer amicus briefs than there are now. Mm-hmm. And the briefs had unlimited number of pages. Did that present any difficulty for you?
To have fewer briefs?
And more pages of the briefs, the party briefs.
Well, how did it work out overall? I'm in favor of fewer. Not really. Yes, there were perhaps, I don't know. That did not make an impression on me one way or the other. I know that now, and remember now, it's a different world, and not just that it's a different political world. The court is in a different situation vis-a-vis many of the basic protections, simply because of the passage of time and developments in the country, regardless of who'd be president of the United States. And so it's a different court. And we're more, I'd say, well, you're deciding cases as they come up, which is what judges do. And amicus briefs, I think they're very valuable. And it depends, of course, on the brief. But it's not just that when I found them valuable, well, particularly, this is personal, but I find them particularly valuable when they give me a point of view that otherwise I won't get. Not just in the law. When we had the right to die cases, we had briefs from nurses' associations who favored the existence of a right to die and some that were opposed to it. People who worked in hospices, people who worked with retarded people, people who worked with disabled people of different kinds, people who were doctors, people who were, the hospices all over. Now, I think that's both pertinent and useful. Sometimes we'll just get a set of 30 briefs. Normally we'll have about 10 or 12 in a case. But if I get a brief from the American Psychological Association, I want to know how a decision, one way or another, will affect their patients and how they treat them. I really don't want, because I probably won't need, them to say to a lawyer, go write a good legal brief and then sign our names so they'll know we're on one side or the other. I say, okay, that's interesting. And on to the next one. But when they can tell me something that I don't know, good. It's often
you try to read the amicus briefs, most of them?
I do read them. Now, how do I read them? What I do is, this is different from the certs. The certs, I'll rarely read the brief. We get memos, and I usually say, I'll go through the memos pretty quickly. And I won't just follow the recommendations, but I'll go through them. And there I say 150 a week. It's better to have the law clerk go through each of those briefs with great care, and then write a memo, because he'll find that needle in the haystack, than to have me pretend to do it, because that's what I would be doing. Okay?
Justice
Now,
Brennan
it's
used to
different.
read the question presented. He said that he used to read the question presented. He could tell from the question presented as to whether he was going to grant cert or not.
No.
No.
What you want to look to, but it's almost the same. It's almost the same. Most of the time, the key thing is there a division of opinion in the lower courts on the same question of federal law. That's what President Taft said we were there for. He said that, everybody's had one trial, one appeal, and most of it, 2 or 3 appeals. And so why do you have another appeal to 9 judges who, why? Well, he said the best reason why is because federal law should be uniform. There shouldn't be this place here and the other one there, and if there is a division among the circuits, a real division, and the lawyers who work, they're good lawyers in the Supreme Court bar, very good, and they understand the court, and and also, if they want their case granted, they're going to try to say there's a split, and so some of it you have to say, well, is it a split? Well, this court over here used the word, I don't know, Ishkabibble, and the other one used the word Jochenfloster, but they're after the same thing. That's not really a split. And but that's what I'm primarily looking for. And now there are some other cases too. But go back to the amicus briefs. How do I do that? What I do, if it's
on the merits we're talking about.
Yeah. Now the briefs on the merits, I usually start. I'll read those. I can usually read 2 sets in a day, and we get the 12 boxes. If
you're hearing 12 cases, that
we're usually hearing 10 to 12 cases. Recently it's gone down again. That's not our doing.
you do get.
You must have some that you think we should have granted.
Yeah, I know.
Oh, yeah. Okay.
Not me. Oh no.
No, not you. Okay. Perhaps you're right.
No.
But I tell you, from the psychological point of view, people are looking for cases to grant. Sandra O'Connor used to sit there and say, "We've got to find cases." And I look at some of the cases we granted and say, oh my goodness, why did we grant this case? I won't say which ones. But nonetheless, we're not in a mood of trying to not take cases.
Well, you're hearing now only about 70 or 75 cases a year.
That's because
you used to hear 150. You went on a diet.
What I think, my own explanation, and you're off in a different subject because I want to go back to the...
Okay.
But the that's all right. My own belief. You see, a lot of these things I don't know more about it than loads of other people, and why it's gone down like this. My own theory of it is in the first of all, years ago, there were a lot more appeals, and not certs.
Yes.
So we have discretion with certs, not with appeals. If you look at the ones that come up in appeal, there's a much higher percentage taken because we feel we have to take them. Okay, so certs now have grown, that is more discretionary power. Second, at the time of the Warren Court, and during the 60s and the 70s, lots of legislation was passed in Congress. All kinds of things of important legislation, and Justinian, Montaigne said this, very good. He said, he said it about, I forget who he said it about, but nonetheless, he says, for a lawyer, each new statutory word does not clarify things. Rather, it produces a challenge. So for every new word that you have an argument. And that produces lots of cases. And in addition, you had this selective incorporation, which suddenly changed the environment and the law in respect to many important constitutional cases. So it isn't surprising to me that even after the discretionary power of the court to say yes or no increased, you still had a lot of cases. Because with the lag of 2 or 3 or 4 or maybe 8 years, you were getting a lot of those arguments in the Supreme Court. Now, let's have a period where they're not passing a lot of laws and where the Constitution isn't changing tremendously, and you will see fewer cases. Now, that's my explanation. But there may be others. I don't know. But I do know we're not trying not to take cases. What more can I say? On the amicus briefs, how do I do it? What I do is if a normal case has maybe 15 briefs, maybe 12, maybe 18, that's all right. You see, I'll usually I read the opinion below. I want to know the opinion below. That's what they're challenging. I'll look to the argument on the blue brief. I'll say, what's the question? When I read the question, I think I know the answer. I read the blue brief. I say, yep, that's the answer. Then I read the red brief and say, oh, no, it wasn't the answer. And that actually, I mention that because for your students and the others, I think that's what open-mindedness is. It's not a blank slate. Of course you have views. And by the time you're a certain age, you have a lot of them. But what is open-mindedness is being willing to change your mind when faced with facts and arguments that point you in the opposite direction. And that's what happens as you read the briefs. And it happens in oral argument to a degree still, but the window's closing, the gap is getting narrower, the room for change is getting smaller, you're becoming more definite in your opinion. So I'll normally be able to read the amicus briefs in those cases where there are 50 or 80, once 100. Well, how did I deal with that? First, let's save them for a while, read the others, then read the ones that I, for whatever reason, think are likely to add something. And then, as you've read those, you look to see in the table of contents and the argument, the summary, and blah, 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 like that, are they adding something? Parents involved, an important case of affirmative action, sort of colorblind constitution.
Seattle case.
Yeah, the Seattle case. I thought that the amicus briefs there added a lot. We had a copyright case where I thought the lawyer who wanted to challenge whether you could distribute once you bought a book in Singapore. It was a great case for students too, because it was a student from Bangkok, I think, who went to Cornell, and he discovered his textbooks in English were a lot cheaper in Thailand, and he said to his parents, "Send me a few," and they sent more than a few, and he had a nice thing going there, the question, the publishers got a little annoyed, and they brought a law case, and the question was this obscure set of words in the statute mean that once he'd bought the book abroad, could he do what he wants with it? We had loads of briefs in that, but they were so organized as to give us, it was obvious the lawyers had, deliberately organized who was going to talk to us and how, and they gave us a picture of copyright that spread across the world, that spread into many different disciplines, many different fields, automobiles, software.
You heard that issue twice, actually. And the first time, as I recall, it was divided, and the next time it was 6-3.
That's right. But my point is that sometimes amicus briefs are extremely helpful, and a lot of them are helpful, because they'll give you somewhat different points of view, spread the knowledge, and I think we'll pick those up, personally pick them up. And I will sometimes, or somebody will say to me, be sure you focus on that brief. Be sure you focus on it, because there's a very good.
Your clerks read all the
Oh yeah, of course. I read them, and then.
And they sometimes tell you which ones you ought to focus on.
I've usually read them before they've read them, but I will go through them. I'll try to get through. This is just personal. You could do it otherwise.
It's your
habit. But no, it's habit. I read through them. Try to finish them a week or two, or maybe a week, or a few days anyway, before the oral argument. And then my clerk has been reading them, but then I'll talk to the clerk and say, these are the things that were worrying me. I want you to write me something that has that and anything else you want. So they'll write a memo, and then I'll go back. I say, there are 4 of you, let's say, and there's 1 of me, so there are 12 cases, so you have to know it 3 times better than they think I'm a mathematician. But nonetheless, then we proceed, we discuss it. We have a lot of discussion in my chambers. And we did in Goldberg's chambers. We had a lot of discussion. It was fun. And I hope it's nice for them, and it's nice for me.
So after you left Justice Goldberg's chambers, you went to the Justice Department, the Antitrust Division, for a couple of years, and then you went on to Harvard Law School, where you went on the faculty. When did you think about becoming a law teacher? Do you recall the first time you thought about it? Seriously?
Probably when I was working in the Antitrust Division. Probably when
I
always thought it was something I might do. It was certainly always there when I was working for Don Turner.
And he had been
a professor at Harvard.
Yeah.
And I was his special assistant.
And what did that entail as a special assistant? Did you do any cases?
All sorts of things. Charlie Nesson and I argued a case, oddly enough, that was before the Fair Housing Act. But Charlie was working for John Doerr, who was head of the Civil Rights Division. Mm-hmm. And there was a case that we'd worked out that others did too, of course. So there was a case to agree not to show, say, African American customers houses in white neighborhoods was an antitrust violation. Why wasn't it? And so I argued that in front of the Sixth Circuit. That was my practical experience. So I haven't thought about that for a while, but it was.
Did you win?
I think we did win, but you see, the Fair Housing Act became law, and that was superior.
So you didn't need the antitrust law?
No, we didn't need the antitrust laws. There we are. But yeah, and but I wanted to. I thought antitrust was a very interesting field, and I wanted to teach it. And there were only a few cases. You see, fabulous. You could master the whole field in just half an hour.
Phil Rita wouldn't say that.
I know. Oh, Phil Rita was great. Wonderful.
What enticed you to go to Harvard and become a law professor? Do you remember? What sort of?
Well, they offered me a job.
Well, but you had a job, and you probably could.
I had a job.
You probably could have gotten some other job someplace if you tried really hard.
Yeah, I mean, I'd been to Harvard Law School. I felt that this was it was certainly a privilege to be offered a job at the Harvard Law School to teach there. And as it is at many, many law schools now.
But it wasn't, the pay was quite low back
Every different job I've gotten has had a beginning pay lower than the last one.
Maybe that's why
that seems to be
I
a
specialize
sort of,
in that too.
Yeah, I know you do.
I thought I had a monopoly on it. But
yeah, right. At that time. Well, anyway, there we are.
Well, you didn't take a pay cut when you went to the Supreme Court from the Court of Appeals, at least.
I had to stop teaching.
Ah. Okay. All right. And what did you enjoy teaching?
Yes, I love teaching.
And writing.
Writing has always a strain. It's always agony. It's always agony. And I think the pleasure that you get out of writing is that you finish writing what you write. And you think, but teaching, my goodness, I mean, and particularly, you move along, the students they're thinking, and they're not respecters of persons. You better have a good thought there, and you better be able to express what you want, and you listen, and goes back and forth, and I really enjoyed that. I do enjoy it. I love it. And it's...
So, on your writing, you've written 3 books on the court, plus a book before then. If you don't enjoy writing, then why are you continuing to do it? You get some writing drill every day at your regular day job, right?
What do you mean a book before then? Haven't you read the regulation of federal power of energy by the Federal Power Commission, which is only number 2,867,000 on the Amazon list?
What about your regulation book?
Yeah, the regulation, and there are a couple others on regulation. Can I tell one?
Many.
All right. The L.A. Times got hold of one of those books. I think it was that one. For some reason, I was in the First Circuit when it came out, and a reviewer reviewed it for a pretty technical book. And this is the review. He starts off. He says, "In the Alice in Wonderland, Alice and the Dormouse emerge from the pool of tears. The Dormouse begins to read from Hume's History of England. 'Why are you reading that?' says Alice. 'Because,' says the Dormouse, 'we're wet, and this is the driest thing I know.'" He says, "That's it, right. That's it." That's it. Never mind.
I think I wrote a blurb for the back of that book.
Good.
I don't think I said that.
Yeah.
I said anybody who's really, really, really interested in regulation ought to read it, but
Yeah.
nobody else.
Oh, no, you did not say nobody else.
I didn't
That's
say
why
that.
it's been a bestseller. And
But your books on the court, I think this is a change from when you were a clerk, that the justices didn't write. Well, Justice Douglas, of course, wrote a lot of books, but mostly not about the court.
Joseph Story wrote volumes.
Yes.
Joseph Story wrote treatises.
But they're different kinds of books than the kind you've written.
Well,
Rehnquist
wrote a lot. Rehnquist wrote several. They're very good books, too.
On impeachment.
No, he wrote a very good book on the Supreme Court. You want a book that's clear and explains the workings of the court from the Chief Justice's point of view, it's a good book. And I thought also it was a good book, though he couldn't cover the whole thing, is The Constitution in Wartime. As he went through a number of the Civil War, the World War I, and he discussed the cases, and there aren't that many, that had come up in time of war. It's a good book. And he was working, when he died, he was working on another one. The reason that you write books is, if somebody has had this, is you write, you can't help it. And this is a teacher in a sense. I mean, and lawyers have there's some of this in them too. You like explaining things to people. You do.
Or trying.
And you try, that's right. And you have experience. Why write about the court? Because I have an unusual experience. That's what Harry Blackman told me when it was his seat. And when I talked to him, he said, "You'll find this an unusual assignment." Mm-hmm. Right. And, but you want to explain to people, what is it that you see? I mean, this book is about the court and the world, is really about the cases in front of us that require us to look beyond our own shores. And my point is there are more and more, and I try to say what they are and group them and so forth, so that the real question is, how do we deal with them? It isn't some argument whether they should be there or not. They're there, all right? And they're part of the law. But what am I trying to do? I'm trying to explain it from my point of view. That is the experience I know. Because there are many, many law professors who will know the field much better than I. But I will know what it's like to be a judge working in that field, and that I can explain. And I want people to understand it. I want people to understand how the court works, and you're the best way to get that done, not me. I says, you're the ones who can, the lawyers and the students and the others. I say contrary. I'll tell you, well, a woman who was president of the Supreme Court of Ghana is in my office. And she says, and she's trying to make her constitution and the law there more susceptible to protecting democracies and human rights. And she says, why do people do what you say? Mm-hmm. Right. And there's a long history there, a long history of sometimes not, a civil war, 80 years of segregation, all kinds of things. So the best to do is to explain that history, or to discuss it briefly, or to say it's custom, it's habit. Americans do, and they don't think about it. Good. That takes a lot of work. And my own view for her was, you want a rule of law, and the rule of law is easy when you get decisions you like. It's not quite so easy when you get decisions that you think are important, harmful, and wrong. Yeah, that's when the issue comes up. And at that point, if you have a society, basically, that will follow it, you're getting a rule of law. If you can keep it, that's, etc. But I say to her, so don't. It's not the people. The judges already agree with you. The lawyers do too, they're making a living out of this. But contrary to popular belief, 319 million people in the United States out of 320 million are not lawyers. And they're the ones that have to understand it. So I say, when I talk to a group of students or others, I say, Law Day, go out and talk to a newspaper. Go out and talk to a high school. In Boston, they do bring high school classes into the federal courthouse so they can see the case and discuss it and debate it. Good. The more of that, the better. And they have to understand it. And if they don't understand it, forget it.
The last time we had one of these conversations, I promised you I wouldn't ask you about cameras in the courtroom, so I won't ask you about that now, in trying to get people to understand what goes on in the Supreme Court, because it's going to be a while, right?
I think it'll be a while, and the reason is it's easy to see why, and if you want my most pro feeling on it, it's when we had a case like that Arkansas case, which was the question of the constitutionality of term limits on congressmen. Members of Congress, they wanted to no more than 3 terms. And you see, look at the Constitution. It is really evenly balanced, really evenly balanced. I mean, it says you have to be, say, 25 years old and a citizen of the United States, a resident of the state. Doesn't say those are the only things. Couldn't they at least prevent lunatics? No, they don't even want to. Couldn't they have a property qualification?
Felons?
Felons? I don't, yeah, well, there are. Let's not go into detail. That's
what I get to debate with my students when I teach that class.
Perfect.
I say to them, and that's what you mentioned.
But my point on the cameras, if people could have seen the oral argument, they would have seen 9 people who are sort of struggling with this thing. It's very tough, and there are 2 sides to more questions than you think, and they're pretty tough.
Even in the cases that go 9-0, you
Of
see.
course there are, because even in the 9-0, you happen to go a little bit like this and say, okay, all 9 go like that. The fact that it's 9-0 doesn't mean there weren't 2 sides to the case, and doesn't mean that it wasn't a difficult case. All right? So now why not cameras in the courtroom? Well, it's a risk. No going back. Some of my friends in the press say to me, don't do it. Why not? Wait till the first time that you see somebody saying what went on, saying it totally wrong, having a picture like you, perhaps looking like Torquemada, but not taking your words out of context and making a big joke of it. Now, so what? If you ought to be used to that. But you will watch what you say. And I don't want to watch what I say. I say in oral arguments some particularly ridiculous things from time to time. Okay, that's my problem. And you want the judges to be, and the lawyers, you want to get, if you can, get them into a conversation. And so we don't know what will happen exactly.
But we get to listen to them at the end of the week now anyway. That's
Fine,
always good.
Listen's great.
Oh, so you're okay for radio?
Sure. And we do it.
So I think that one of the great things would be to have the announcements of the opinions when the justices read from a short summary.
You might. Hasn't come up.
Hasn't come up. Well, it just came up now.
I never take a position without thinking it through.
I'm not asking for this.
I don't know.
I want to change the subject for a second and ask you, in the late 1978, I believe, you took a leave from Harvard to come to work for Senator Kennedy.
Yeah.
It's quite a different world from teaching at the law school. Tell us why you decided to do that, what you got out of it, other than possibly your appointment to the First Circuit.
Certainly that was a fluke. And I mean, a judicial appointment, I'll tell you right now, it's like lightning striking. And everyone on the Supreme Court knows that not only did lightning have to strike, it had to be struck twice in the same place. And that's not phony. Everybody knows that. That there are a bunch of other people who could have been appointed. I wasn't an appointing person. Nobody thought when I went there or anybody else working there was going to lead to some other thing. But it was fabulous. I loved working in the Senate. I loved working for Senator Kennedy, I mean, every day we'd go on a bicycle. And be there early in the morning. And by the way, every single morning, we being Ken Feinberg and I, would have breakfast with Emory Sneeden, who was Thurman's chief person on judiciary, former Army.
He was a Republican, though.
That's my point.
Yes.
And we would plan the day. And no surprises. What we used to call it was open conniving, openly arrived at. But the fact was that it worked. It worked. People liked it. And when there were judicial nominees, they would be jointly investigated. The first team was Duke Short, who was Thurman's person, jointly with Carmine Bellino, who had been Bobby Kennedy's investigator, and then later Burt Wads. And the two of them almost always, I can't say always, but almost always, would write a joint report, and it was very rare that we wouldn't confirm people. And it would just go through. And sometimes the report, on a few instances, that report was negative, and then it wasn't a partisan division. So it was a different world. I understand that. People tell me that. But it was great. And Kennedy, those other things on the cup, God, he was fun. It was fun and interesting, and I think his view was, I heard him once say this at a staff reunion where he was just talking what he thought. And he said his father had told him, you get people together, people of different views, different abilities, different capacities, and you get them to help. Help what? If you're in the staff, help him. Help yourself, but help somebody else. And you'd sort of compete with him, with the other staff members for time. And if he saw something was working, was going well, he'd give you the time. And then you could make some progress. And I put on that cup, I'd say one of the things is, don't worry about credit. I'm not saying he was immune, but nonetheless, don't worry about credit. What he'd tell us is credit is a weapon, and you use it to get people together. And if the thing works, there'll be plenty of credit to go around. And if it doesn't work, who wants it? You see? And the way you'd compromise, you don't say, I'll go here and you go here, and then no. You listen to what the other person says. You listen. And then sometime, if the conversation goes on long enough, you'll find something that you agree with. And then as soon as you find that, you say, what a good idea you have. What a good idea. Let's see if we can work with that. And then if you manage to work with it and get it with other things and so forth, and the thing does go through, time after time, the press wants to know how this, you push the other person out in front. Push the other person out in front. And then maybe next time they appreciate that. And I learned that. I mean, I cannot tell you the amount that I felt this was valuable.
When you started, you didn't know that you were going to learn all these great things. What prompted you to decide to leave Cambridge for a couple of years and come down here and work for Senator Kennedy?
I worked for him twice. The first time was in 75. And I'd worked that summer preceding for Archie Cox, trying to organize they'd had hearings in the Senate that Jimmy ran on the Dita Beard memo. Only a few of us remember what that was.
I remember Dita Beard memo.
But it was part of his Watergate investigation, and I was down there that summer trying to put that together, and probably he might have later recommended me when Kennedy became chairman of Administrative Practices Subcommittee. I was teaching administrative law, so he invited me down he wanted me to be, I took leave and came down to run a hearing. We went through it, and I'll tell you, you won't like it, but I'll tell you that we ran hearings on airline deregulation. And we thought that was a good subject. The reason we thought it was a good subject was, and I still think it, because the prices were too high. The theme of it was business travelers happy to find a seat on which to rest his briefcase. Does he know he's paying full fare for the briefcase? And so by introducing competition, see a lot of people come around that. Competition, less regulation. The ones who didn't want it, Ralph Nader wanted it. I wanted it, the economists wanted it. And the industry didn't want it. Nor did the regulators. And they didn't know what competition was, at least not price competition. So we had hearings on that. And it's still around. Nobody that was actually Andy DeVorney, who is always at one company, I think, somebody who really knows the company well and is never the president, but he's high up. But that at United Airlines at that time was a man named Andy DeVorney. And we went out and were talking to various reasons, going through some technical stuff. And he said, I think actually you're right, Stephen. And we were with an economist. He said, you should have price competition. You know what? The airlines will fill up. Prices will come down. But you, Stephen, will hate it. Well, there we are. Go look at the prices. They're about half what they were in real terms in not every, but half, an average, in 1973. And you can't find anybody who likes it. Unless you try, of course, to start an airline that will give people much better service, really comfortable, very good food, and charge them 50% more. Unfortunately, all those airlines go bankrupt, because I guess people prefer the lower price. All right, that's my defense. That's very defensive. But that's why I came down to work on that, and that went pretty well, I guess. And then when he became the chairman of the Judiciary Committee, he called and said, would I come down and be chairman? Not chairman, chief counsel, when he was chairman. And my goodness, that was fun and interesting and just a fabulous, I mean, I loved it. I really loved it, going in there every day. It's like you'd work with senators of different parties and try to accomplish something that was constructive, and it was good. It was really great.
Near the end of your term, and right after the presidential election in 1980, you got nominated and confirmed for a position on the First Circuit.
Yes. They couldn't agree on anyone else. And
But-
there I was.
But there was a trade-off, wasn't there? There was didn't one of Senator Thurman's people get confirmed for the
No, as far as I know, there was no trade-off.
would that have happened? Could that have possibly happened today?
Well, you're the one who would know that better than I. It's true that I was nominated. I mean, there'd been in arguments, actually, go back to that history, which, I mean, for most of the year, we were trying to get Archie Cox nominated. And he was, Jimmy Carter, who was president, wouldn't do that. He said he was too old. Well, maybe that was possible. I don't know. We didn't think so. And then they turned to try to get someone from Puerto Rico, and then they would try. And there we were. It was September, and nobody had been nominated to this vacancy, which was in principle a seat that normally a Massachusetts resident held. And so the senator had the idea, what about Breyer? And Senator Thurman thought it was okay. Well, there we are. And it had its moments. I mean, there was a filibuster.
But they didn't stop you. They could have.
They didn't, because Senator Laxalt came in, if you're interested in this detail. Senator Laxalt had been on the committee, and he was a campaign manager, or very high up in the Reagan thing, and he voted against the filibuster. And that was significant.
Yes.
And others did too. And it was being led by, oh God, this is really ancient history. I mean, there had been a nominee from one of the Democratic senators' states during the year for a judgeship that we came to the conclusion there was something, a real serious ethical problem with this particular individual, and they pressed it, and Kennedy and a majority of the committee wouldn't confirm him. And so that was perhaps involved. I'll tell you the whole story someday, but there aren't going to be that much interest in this very large group.
In about 1984 or so, you were chosen to be on the Sentencing Commission. Mm-hmm. Did you work on sentencing at all when you were working for Senator Kennedy?
Well, it was primarily Feinberg's responsibility. I say that we had a little bit to do with it. It was in the reform of the criminal code, and afterwards, I remember this. It was October 1967, and the reason I remember it is
67. No.
Yeah, 87. Right, 87. And a few weeks earlier, the stock market had crashed. So I was having lunch or dinner in the Fifth Circuit at that time, 11th Circuit it was, and explaining to the judges what these guidelines were supposed to do. They're supposed to bring uniformity to sentencing, so forth. And he said, well, what did you do before you were a judge? And I said I'd taught, and I'd worked for Senator Kennedy. He said, what did you work on? I said, I worked on airline deregulation. And he said, you worked on airline deregulation, did you? I said, yeah. He said, and you helped produce these sentencing guidelines, did you? I said, yes. He said, they didn't just put you in charge of the stock market, he said. All right.
So, do you recall a conversation you and I had about the time you got on the Sentencing Commission, when you called me on the phone and said to me, Alan, I have this question for you. He says, I'm on the Sentencing Commission, and there's some commissioners here who want to meet in secret. And I said to you, Well, they can't do that. It's covered by the Federal Advisory Committee Act. And you remember what you said to me?
No, I don't. I usually remember everything I ever said to you, but somehow I don't remember.
So you said to me, oh, no, it's not an advisory committee. I said, what? He said, oh, no, we're actually going to write binding guidelines. I said, you can't do that. Who was on this commission besides you? It resulted in an unsuccessful effort by me in the Supreme Court, in which the Sentencing Commission was represented separately by Paul Bator, and the Solicitor General, Charles Freed, was representing the Justice Department, and I lost the case 8-1, Justice Scalia siding with me, but eventually the court moved away from mandatory guidelines to permissive real advisory.
No, the idea of the guidelines, which says it in the introduction, is that judge, if you have an ordinary case, we tried to make the guidelines reflect what, say, 65,000 previous cases which had gone through computers and so forth, what really happened to these individuals and what were the variables. And when it's this, and when it's that, it's that. And we based it on what really was past practice and what the guidelines say at the beginning, and they still say it. They say, judge, if you have an ordinary case, apply the guideline. Judge, if your case is not ordinary, depart. When you depart, write your reason. Write your reason. And that will be reviewed in a court of appeals for reasonableness. And then what the commission is to do is to gather the results of all that and use that to improve the guidelines. So it's supposed to be a 3-part iterative process. And gradually the guidelines will supposedly get better over time. That was the theory. That's there in to this day in the introduction. And the reason you had the reaction you did is because a lot of judges just applied the guidelines, not looking too much to see if it was not an ordinary situation. And of course now it has changed to a degree, and perhaps they do that more. But that was the original purpose to begin with.
So you think it's back to where it was
where it should be, pretty much. It depends on how many departures there are. It depends on how often you don't want them. It's a similar system existed in Britain. What you do is it's called the tariff. And if you have an ordinary case, this is the ordinary punishment and for this kind of behavior. And it brings about greater uniformity so that the sentence depends upon the behavior of the individual rather than depending upon which judge you happen to select or which part of the country you live in. And that was the theory of it. And so having a significant number of departures, fine. Having everybody, if you never have, you don't want to reduce it to nothing. What you want is to create greater uniformity, not perfect uniformity. And that was the idea behind them. And I suppose that the court now has made that, I think, more likely. But there's still problems with the guidelines, I understand.
I want to turn to the death penalty subject now. And at first, can you take us a little bit behind the scenes and talk about the situations which appear to be fairly common, in which sentence is about to be carried out, and the court gets last-minute papers? What happens? How much time do you get? Do you get notice? And how does that work internally? Because it's something that's hidden from the world, and it's always interested me as to how those literally life and death decisions are made, by whom, and at the last minute.
Well, first, I suspect that almost every instance where a death penalty is about to be carried out will come to our court at the last minute, usually a day or two ahead of time.
Day or two.
Normally, except for in rare instances, there have been years of litigation. I thought I've written far too many years. It's one of the problems with the death penalty. 40 years we had something, all right, in any case. Now, what will happen practically is very few issues have not already been litigated and brought up and been to the Supreme Court in form of cert petitions several times, possibly. But sometimes there are some that do have a pretty good legal point, and it wasn't previously decided, and there it is in front of us. Right. Before an execution, there are staff people, permanent staff people in the clerk's office who follow the death cases. And they will know, usually a week or maybe 2 weeks, ahead of time. And then there will be, and they'll know what it's about. And
So it's not quite the last minute scenario that it was.
No, and then there will be a person, a judge, one of us, in charge of each circuit.
Yes.
And so, for example, quite a few come out of the 11th or the 5th Circuit. And so that judge, knowing that from the clerk that it's likely to come up, will have one of his own clerks and say she'll go and follow it. And then at the last day or two, when it's filed finally, and then there'll be somebody, I mean, they know, I have a list of what's likely to come up stretching out for a few weeks right now. So I in my office, I have that. And my clerks have divided those up. There aren't that many now, but they've divided them up and they'll follow them. And then they'll know what's likely. Sometimes it's surprising, but they'll know what's likely to occur. And so the memo will come around from the 4th Circuit Justice or the 11th Circuit Justice and make a recommendation. And then we vote. And sometimes people will have, even though it's only a day.
But you're often not here when the vote...
Well, Gal, get me on the phone. You know, that's the wonderful thing. I thought of turning off my cell phone and I realized I was running a risk. But it is unlikely, I agree, that somebody's going to phone you from your own staff while you're sitting on the bench in the Supreme Court. That doesn't. But in any case, they'll find you. They know where I am. And therefore, we will hear, even if I'm, that's sometimes difficult to organize, but it is organized. So that I will, with at least a few hours and usually a day or two, know what the issues are, understand the arguments, which are usually fairly easy to understand, and see if it is that one of few cases. And then we vote. And very unusual that somebody misses that vote. But it isn't somebody voting for him, it is the justice voting. And they can't vote for me.
You all get on the phone together and discuss it?
No. Sometimes we'll issue a stay so it can be discussed at conference. That's rare, but it happens. And usually it's a question of a stay. And in most cases it's denied, but sometimes not. And then if I might, for example, or somebody might write a dissent. And if I write a dissent, I have to know a day or two. And I think it's likely to be a dissent. I'll get it drafted and I'll look at it and I'll write it. I'll sit down and do whatever thing I want there with the. And we had one with the 8 executions out of Arkansas. Yeah. And I had written that and probably a day before, circulated, because I think maybe somebody will look at that. And sometimes they do, and they say, maybe we should discuss this. But it is up to the justices. They do look at the things. They do know the issues in the case. They have gotten a memo from one of their number. They may have gotten a couple of memos, and they will decide. I think it works reasonably well.
Your opinion in 2015 suggested to the court that the time had come to revisit the death penalty issue again. When did you start, if you remember, to get interested enough in that? Obviously, that opinion was not written solely in respect to the case before you. It looked like you'd been thinking about it and working on it. What got you interested? You certainly didn't have very many death penalty cases on the First Circuit.
No. I think that what happens after you're there for a while, you begin to get, and I think that happened with Stevens, and I think it happened with Lewis Powell, and I think it happened with Harry Blackmun. You get the feeling that what I said in the opinion, this is random. Now, it's one thing to say it, and it's another thing to sit there over a long period of time and begin to think, yes, it is. It is. There is a problem here. There is really a problem. And so then I thought, Okay, I can say that, but what do I add, really, to what other justices have already said? Arthur Goldberg wrote an opinion on this years ago. And I thought, well, I could add, say, I agree with them, and people say, that's very interesting, that's nice, fine. Or I could try to do something that would, in fact, be useful to others. And therefore, we spent considerable time with
How
my
many
clerk.
years did you spend working?
I'd say a year and a half. And over a long period of time, gathering the information, trying to organize it, trying to work out the thinking, and trying to say, look, I'm not going to say it's unconstitutional either. I'm going to say we ought to consider it, because that's what I think. And of course I shouldn't. I mean, in my opinion, you don't decide a major thing without hearing argument. So I wanted to make that point too. And so I said, well, look at the facts, look at the figures, look at the situation. And now, that's sort of my style in a way, or lack thereof. If I'm writing a decision, if I'm writing an opinion, and if I'm writing a dissent particularly, I want anyone prepared to spend the time to read it to say we're sort of moved in this direction by the facts, by the law, by the argument. It's not my personal view. It is, there we are. And I think it's particularly true with this one. I mean, you want people to say, look at that. Oh, gee. Let's think about it. Let's think about it. Let's think about it. And that's what that opinion is intended to do.
So the opinion talks first about arbitrariness, randomness, and delay.
That's right.
And delay is a kind of a two-edged proposition.
I know.
Because in one sense, if you have speedy executions, you eliminate the delay problem, but you worry much more about wrongful executions and wrongful convictions.
That's right.
And so how does the delay fit into your notion of the constitutional analysis?
Well, that's where I ended up, you see. I said where I think this leads is that there are two major circumstances that are at loggerheads. The reason there is all this delay is because there is endless occasion to worry about whether it's the wrong person. So you want to be really sure that those procedures are thorough and complete. And even then, sometimes there might be mistakes.
And whether the death penalty is appropriate under all the circumstances.
Correct. All right, so what that means is it's going to take time. We don't know if it take this much time, but on average, 18-year delay. We had a case where the other day where I wrote something and I couldn't, it was 40 years.
40 years.
40 years, but I mean, really. So my point is, penologically, I mean, going into a system where in fact it will be, the person would be executed after 18 years, average, maybe much longer. What penological purpose is that serving? Vengeance? He's a different person. Deterrence? It's random and few. I mean, what? So, but where I'd ended up, and I said this at the end, that it seemed to me you can have either a system that really is reasonably fair and tries to correct mistakes, or a system that has just some justification in criminal penology. But you can't have both. And if, in fact, you want both, you can't get it. But as long as you don't have both, I ask the question, what justification is there under the Constitution for having a death penalty? That's a little too clever by half. But I hope that by the time you read, or someone reads, the few, 43, but who's counting, pages of facts and figures and so forth, a person will be driven into a state of mind where he'll say, maybe that's right. Maybe that's right. Maybe we do have to hear it. Maybe we should think about it. Maybe we should consider it, etc. Okay? That's what the opinion is trying to do. I'm not saying it's the only approach. I'm saying it's one approach. And I ended up saying we should consider it.
As you know, there are many fewer executions now, many fewer convictions that could lead to an execution. Some people say we should still keep the death penalty around to deal with the worst of the worst, and that the politics of it will work out. The juries will no longer give the death penalty except in the most extreme cases, and that legislatures are starting to realize the tremendous cost in human life and in actual money to keep people on death row forever, and that maybe this is an area where the court should stay out of it, and that if the court stepped in and ruled the death penalty unconstitutional, we would have a big fight in the election about amending the Constitution to allow states to do it. Does that kind of thinking sit at all in the back of your mind when you're thinking about these kind of issues?
Not much, no. I don't think so. I think as to whether it has been limited to the worst of the worst, I have a section where there was a big study in Connecticut and so forth, and it's very hard to say it's given to the worst of the worst. That again, you see, if you see enough of these, you have a subjective feeling, but these are, I mean, some they are, but some are not. And then you look at what the scholars have done there and say they seem to bear out this subjective reaction. As to whether people have a political fight or not have a political fight, I mean, you know, you never can say never about anything. But in the building I work in, I think that is kept to a minimum. I think we try to keep it to zero, and I think that it comes close. And there I'd need you to say, what about Bush v. Gore? I think I might be able to convince you even there, but it would take me an hour and I might never succeed.
And we could separate your vote on the equal protection from your vote on the remedy issue in that context in any event. You did say that it was a violation, you and Justice Kagan, Justice Souter said it was a violation of equal protection. We have many recent law school graduates and law students here in the audience, and I want to give you a chance to give them some words of wisdom if you could think back when you started your career and what you've learned over the years, what would you say to them if they would like to have a fulfilling career and not simply bring in a paycheck every week or so?
Well, there are a couple of things I often say to students and law students. And, one is, well, to students in general, I say that, you know, I do believe this strongly, and it probably reflects my own experience. But I say I can't tell you what to do with your lives. That's going to be up to you. But I can say I hope you have someone to love. I hope that you have a satisfactory career. And I hope you spend some of your time in public service. It could be any kind. Library board, school board, who knows? And I say, why do I have the authority to say that? I say I don't, except for the fact that I do work with the Constitution every day. And I am reasonably certain that unless you do participate in public events, that document won't work. That's what the founders thought, and that's what I think my experience leads me to think. And luckily, when you come to lawyers, I think we're in a profession that really calls for an exercise of both head and heart. The two. You say everybody has strong feelings, you know. Your feelings are not necessarily better than millions of people who also have strong feelings and maybe totally opposite than yours. Everyone has that, but you do have a pretty good brain if you're in the law, because otherwise you wouldn't be there. And you can contribute both. You see, that is a virtue to our profession. And if you want to be a judge, there's no way that you're going to know in our system whether you're going to be a judge or not a judge. And as I say, a federal judge is like lightning striking. But my father, he gave me two pieces of advice. The first, which I say was true, he always used to say, stay on the payroll. So maybe my pay has always gone down, but I have managed to stay on the payroll. All right, but the other thing, he said, well, It's very corny, but there's some truth to it, and people really believe this who grew up in the 30s. Do your job. Do your job. And do it as well as you can. And pay some attention to what other people whom you're working with or for or whatever it is, to what they're thinking too. And you do your job well and you pay some attention. Somebody might notice. You might get what you think is a better job. On the other hand, they might not notice. And then at least you'll have the feeling that you did at least this job pretty well. So he said, see, it's no lose. And that's always been pretty good. I mean, I have nothing else to contribute here because I don't know the rest of it. You make decisions. Bayless Manning told me that because maybe some of you are about to make some decisions, or younger ones. When I was your age and finishing my clerkship, he wanted me to teach at Stanford. And he said, look, don't dither so much. He said, really. He said, you will not know when you make the major decisions in your life more than about 5% of all the things you'd like to know if you were going to make a rational decision. I mean, try and stay away from things that are sort of slightly nutty. I mean, it's unusual and perhaps wrong if you want to be a trapeze artist, but nonetheless, still, okay? And within a broad range, you make your decision, you do it, and then life sort of wraps itself around that decision. And there you are. And some good things happen. Quite a few have happened to me, very luckily, and then some things won't. But there we are. So he said that was his point. And I always thought that was a good point. I thought it was a good point, at least to be considered by people who are in their 20s and who are making some of these decisions. Another way to put it, more modern, is lighten up.
Well, we have taken a good deal of your time today, Justice Breyer. Thank you very much for coming and sharing your wisdom and thoughts with us, and we greatly appreciate it.
Thank you. Thank you very much. Thank you. That was good.